I'm Daniel O'Toole. I'm a partner at Block O'Toole and Murphy.
I'm Fred Aranki. I'm also a partner at Block O'Toole and Murphy.
The story I'm about to tell happened almost 16 years ago to the day that we're recording. A woman named Jackie Timmons was visiting New York City with her then boyfriend to celebrate Valentine's Day. They were feet away from their hotel room, walking on a sidewalk, when suddenly, without warning, a garbage truck went onto the sidewalk and struck them both, killing them both, and very seriously injuring another person who was walking in the area. One of the complicating factors about this case was that her surviving family lived in England, and the gentleman who asked me to handle the case asked that I travel to see the family. You can imagine the circumstances under which I found the family were quite emotional. She had 4 children, one of whom was quite young at the time of the accident, and they were utterly devastated and traumatized by the incident. Unfortunately, the state of New York has a wrongful death statute that was promulgated over 150 years ago, and the law in New York, as it pertains to wrongful death, is very much still in the dark ages. We don't have a cause of action for a broken heart, for lack of a better word. So in a case like the death of Jackie Timmons, a beloved mother of 4, the fact that the kids' hearts were broken, really there's no cause of action for that. There's no cause of action for grief in the state of New York. It really essentially says that a person is worth what they were earning, which is obviously a rather heartless way of measuring the value of a life. And in the case of the Timmons children, what their mother's loss of advice and guidance was to them.
The main argument that the defense was making was that they had no idea that Mr. Scarlett, the driver of the truck involved in the accident, had any kind of medical condition that prevented him from being able to drive a truck on the streets of the city of New York. Truck drivers are required to have a medical examination, I believe, every year, and provide a medical card to their employer, and he had provided such a medical card and was licensed to drive by the state of New Jersey. So they claimed that they had no idea that he had any kind of medical condition which would have caused a problem for him driving. The driver had a seizure condition which had been ongoing for a number of years that he was required to take medication for. After he had a seizure which caused him to go off of the road and caused the accident, he was questioned about this by the police, and when he was questioned about it, he told the police that he didn't like to take the medication because he didn't like the way it interacted with him physiologically when he drank alcohol. And so when they heard that, he was arrested and charged with aggravated assault and second-degree murder and was eventually convicted.
What could be a more negligent thing than that? Well, we didn't know that until the police investigation became known to us, and oftentimes what happens after an accident is the police investigate, and understandably, civil lawyers aren't allowed to know what's going on because it's an ongoing police investigation. So when we had the case initially filed, the defense to the case was we had no idea he had a seizure disorder. This is what's called an unforeseen medical condition, and under the law, if somebody has an unforeseeable medical condition and causes an accident, they can be let off the hook civilly for that. They're not held liable because it's something that nobody could have known was going to happen. So one of the things that Fred and I came to learn was that there was a federal law that required, in circumstances such as this, with a garbage truck with a particular weight, that the employer, in this case Action Carting, was required to get the past employment files of the driver before they hired him. What we found out in discovery on this case was that Action Carting never got the prior employment file of the defendant. Had they obtained it, which we did, we got the prior employment file, they would have seen that this gentleman had a prior seizure while working for a prior employer. So all the proof was there. All they had to do was follow the law. And when Fred and I discovered that they failed to do this, it took the case to a different level. Not only was it negligent, what happened, but we started arguing about what's called punitive damages.
It was very strange, to say the least. I've taken hundreds of depositions, and this was the first time I'd ever taken one in a maximum security prison in upstate New York. To be honest, I expected the devil himself to come walking out of that room, because this was a man who had callously driven a truck knowing he had a seizure disorder without taking his medication and killed 2 people. When he came out, he was just a regular man. And we took his deposition, and he was pretty forthright about everything. I guess at that point he figured I'm convicted and there's not much more I can do.
All of the parties to a lawsuit have to be deposed in the lawsuit. And again, this was before Zoom, when people could testify over computers. That was unheard of, literally didn't happen back when this case was pending. So we had to be creative about taking the depositions on this case. And Fred and I were discussing that, and he said, well, you know, if there's a non-party that needs to be deposed, it would be incumbent upon the defense, meaning the defense would have to go travel to the UK to take that person's deposition. So Fred came up with the idea of, well, let's take the deposition of the payroll supervisor for Ms. Timmons, and that way the defense will have to fly over to the UK, and they'll have to take it'll be less expensive for our families to attend the depositions, and they'll feel more comfortable because they'll be at home in the UK. I flew over to England and took, I think it was 11 depositions. So it was very helpful for me to travel to the little town they were from in England and spend time with the family, not only preparing them for the depositions, but in less formal settings too, just asking them about their mother, what made her special, so that when it was time for me, if I had to try the case to verdict, to stand up in front of a jury, I always say, I want the jury to know that I love the person I represent, that I'm not just going through the motions. And I can say that after every trial I've done, I can firmly tell you that the jury knows they're not just a number to me. I love my clients, and I get to know them like their family. The case settled for $5 million, and which was, much of it was put into what's called a structured settlement, which is nice in that that amount of money continues to grow tax-free for the rest of the life of the folks that it's compensating. So the Timmons kids are still getting money even though we're 16 years later, and they will for the balance of their lives, and that money will remain tax-free to them for life.